had to tell Zoom what's left.
Let me answer that for you.
No, I'm going to turn the notifications off.
Folks, this is Justice Oversight Committee.
Oh, yeah.
It is September 28th. It's one of our usual meetings from one of our 6 meetings that we have. We do have a full agenda today, and we do have some committee members who are Zooming in. And so I'm going to start. We do have a requirement that we take a look at the process of interrogation, police interrogation techniques for adults and juveniles. And we have decided to look at the juvenile interrogation techniques. And we have with us Nathan Erb, I hope I pronounced your last name okay, from the Innocent Project that maybe can help us direct our focus, give us some information. We were going to have Michelle Charles, our legislative counsel, legal staff with us. She is out today, unable to attend, and we will do the best we can. So Nathan, I'm going to turn it over to you, and welcome. Welcome for offering to help us along on this process.
Of course. Good morning, everyone. It's nice to be with you. I'm sorry I wasn't able to be there in person, but I just got back from vacation. And amidst all the COVID worries mentioned this morning, I didn't want to add mine to the pot in case I brought it back with me. But for the record, my name is Nathaniel Erb. I'm with the Innocence Project in New York. Our office represents people who have been wrongfully convicted across the country. I specifically work in the policy department, so I work with a number of different states on legislation around our issues, including now Vermont, which I'm glad to be here. We focus our issues on the causes of wrongful convictions, the necessary legislative court tools needed to get people back into the courts to prove their innocence, and then helping people on the back end. We have long time focused on the issue of false confessions as it relates to wrongful convictions. We found, just looking at the data of our own cases, that it's one of the most frequent contributing factors to wrongful convictions. So when we look at the individual cases, what are the things we see as underlying problems of the cases of people who have been wrongfully convicted, giving a false confession or a confession that's later proved to have been false through DNA evidence is one of those heightened factors amongst many. In addition, beyond our office, when looking at the national perspective, false confessions are actually the #1 contributing factor to wrongful convictions across the states. So we first started off, as your great state has passed legislation around recording interrogations, and increasingly more and more looking at what are those factors, those tools and tricks used in the interrogation room that have largely been left to the wayside, but maybe that not have put in place enough protections to address the existing wrongful convictions that have taken place, but prevent the kind of fringe cases that happen. So looking at the issue of interrogations as it relates to providing false facts about evidence, so lying to a juvenile or an adult about evidence in their case as a way to coerce a confession, whether done so intentionally, unintentionally, as well as lying about leniency I can provide. So saying, okay, if this really isn't a big issue, if you just tell me what happens or give this information that I think you did this, then I will be able to get you off. You won't do any time, et cetera, even if it's a capital murder case. And then we've found a number of other issues that have related to these factors, whether it's withholding food, whether it's withholding medication, interrogating people over many, many hours throughout the night and not letting them sleep, that have all led into it. But those first 2 factors of lying about evidence and lying about leniency provided, we found that particularly vulnerable persons, juveniles, and those dealing with mental handicaps have been extra vulnerable, but also fully functioning adults have been vulnerable to it. While I know Vermont has yet to have a false confession case that's come to light, I'm hoping that your great state will be join a number of other states that have chosen to act proactively, as well as I hope, but we never know if there is an existing wrongful conviction that hasn't yet come to light. I'll mention Hawaii just in 2020 had their first false confession case, and that person who had been in prison since 2014. So it's very likely, and many exonerees that we have worked with have been incarcerated for decades before their case comes to light. And so hopefully there isn't currently someone in Vermont state prisons that has given a false confession and hasn't had the opportunity to bring their case to court, but acting proactively would be a welcome addition to the states. So largely as we've adopted and pushed for legislation around this issue area, it comes from really the need not just to move beyond training of how officers conduct interrogations, because what we found is the use of false facts and the use of false evidence in particular are tools that are largely left to the wayside in modern policing. I think especially in Vermont as leading the country in a lot of the kind of modern interrogation tactics as a matter of state policy. These are tools that most folks don't really want to use. And we hear from especially younger members of law enforcement, they want evidence-based practices that have been proven to be useful, not just in clearing their cases, but also that they can sleep well at night and know that they didn't bring about something that leads to a wrongful conviction. In fact, also one of the largest trainers of interrogators in the U.S., Wicklander Zulawski, abandoned these use of these tactics many, many years ago in favor of more evidence-based procedures. But what we've found in looking at our cases is the protections within the courts have been woefully inadequate to prevent the false confessions from being properly examined and then prevented from entering the courtroom in the first place. This largely comes from the first case in the progeny of the United States Supreme Court, Frazier v. Cupp, which first examined this issue of deception as it relates to false confessions and found that under the United States Constitution, that there wasn't a necessary protection to automatically preclude use of deceptive acts, that within a totality of a circumstance scope, it is likely that deception can lead to a coercive factor that leads to a false confession and therefore should be automatically precluded. But just under the framework of the Constitution itself, it doesn't create the necessary barriers to entry. The court has continually re-examined this over the years. In a case of Illinois v. Perkins, it didn't look particularly at the issue of whether or not deception should continue to be allowed in the courtroom, but it did further strengthen the need to look at it as a potentially coercive factor. In fact, Justice Brennan, in his concurring opinion in that case, mentioned that deliberate use of deception and manipulation by police officers appears to be incompatible with a system that presumes innocence and assures that a conviction will not be secured by inquisitorial means. And largely, our push to pursue legislation as what is considered here in Vermont and has been passed by other states is underlined by another case, Colorado v. Connolly, which the Supreme Court looked again at this issue of how should we properly assess confessions and the coercive factors. And the court found that the Constitution alone does not protect someone from a false confession outright, that the protections underneath the Constitution are required to find that a confession is voluntary, but it does not have any assessment of whether or not a confession should be reliable and whether or not the existing factors of voluntariness and the totality of the circumstances assessment will ensure that a confession is reliable and fact. And it actually, in that case, called on the states to take on this task, that it is outside the purview of the courts and it is up to the states to put in place legislative measures that encourage their state courts to examine whether or not a confession is truly reliable and what are the different factors that could lead to a confession being undermined as deceptive acts have been used. So over the last couple of years, it's kind of been an exciting time. The first two states have passed legislation last year, being Illinois and Oregon. And now this year, 3 other states have joined. Our office has been working with these states across the country and other states like yours that are considering this as they pass the legislation. I know there are a number of new states that are considering legislation either as a second round next year or putting in their first go at the issue. All 5 states that have passed legislation have focused primarily on juveniles. Other states have considered expanding to adults, but it's kind of a first past the pennant kind of thing, and everyone's really concerned that no one else has done it yet, so we don't want to go too far. So while some states have considered aging up to 25 or going to adults, everyone so far has only focused on the issue of juveniles. So limiting it to criminal cases and criminal or delinquency cases involving a juvenile. In Illinois, which was the first state to pass it by a couple of days, it beat out Oregon. The way that the law is structured is it creates a rebuttable presumption that a confession by a child is involuntary if it was made as a result of a custodial interrogation. So there has to be an actual, the officer has to have custody. It wouldn't apply to, for example, like an officer questioning a child on the street when the child is under arrest. That has been a pattern across the states, largely from a matter of practicality. One, if you have, it's necessary to have a recorded interrogations to really show whether or not this happens. So there really is no way to kind of bring a defense up for a child if the child isn't actually in custody and therefore their interrogation is being recorded. And then it also requires that the officer knowingly communicated the false facts about evidence or the unauthorized statements of leniency. The state of Illinois chose to use the word unauthorized statements of leniency because of that interplay between law enforcement officer necessarily isn't the one who provides the leniency. They don't make decisions about that. So if, for example, if the officer was told by a state's attorney or district attorney that this type of leniency could be provided, but that leniency was ultimately provided or shown to not be fact, if the officer was under the impression that the leniency was going to provide in exchange for the statement, it wouldn't get caught up in that legal limbo. Going beyond that, and I will say Illinois was also passed the broad bipartisan support. And each of the states so far who have passed legislation have enjoyed the support of law enforcement and prosecutors in the legislation that they've ultimately passed. The second state, and I'll definitely take time if anyone wants to dig into the individual states, but I'll just give you an overview first. Oregon passed it. Interestingly, it was actually a former police officer who's now a state senator who led the legislation. They passed a legislation very similar to Illinois' rebuttal presumption of the admissibility of the statement. The difference being is Illinois requires that the state prove that the underlying confession is still voluntary by preponderance of evidence, whereas Oregon went a step further and made it by a clear and convincing evidence, so that there's a higher burden on the state to prove that the confession is still voluntary. And it's not just a 51% chance that it's likely not coerced and not unreliable. That legislation was also supported by the Oregon Association of Chiefs of Police and the State Sheriff's Association. Utah was the third state that passed legislation across completely unanimous lines. This is the first bill that I worked on in the states. This was passed this spring. The Utah is also the more strict law so far on the books. It renders a confession by a juvenile inadmissible totally. If the custodial interrogation, an officer used false statements about evidence or leniency, as with the other states. The difference being is there's no rebuttable presumption in Utah's law. There's a court rule to which applies to the statute that says if you do not follow the statute, the confession itself is inadmissible. So if a defense attorney proves that a officer used false facts about evidence knowingly, or if they lied about leniency to a juvenile, the confession or underlying statement is totally inadmissible. Another item that they added to that was, since there wasn't an ability to prove that the underlying statement would be reliable, we added language to the bill that said that the false statements about facts are reasonably likely to elicit a false confession, to kind of get at this issues we have in other states of if an officer is lying about who their favorite baseball team is as a way to build rapport with the suspect, or if they are lying about the identity of someone who provides evidence as a way to protect them as a vulnerable witness, then those type of cases wouldn't be caught up in this and they wouldn't be precluded from the admission of a statement. The new states that have, I will say also Utah was unanimously supported by all law enforcement agencies in this state. So the AG, the Attorney General, the state district attorneys, the law enforcement, all law enforcement associations, and it was passed unanimously across party lines. It's also the first conservative state to pass legislation. California just passed legislation this spring. It was just signed into law 2 weeks ago. California is the most expansive bill. California's bill only applies up to the age of 17 as the way that they were able to get that passed. Originally, their legislation considered up to age 25. In addition to false facts about leniency or false facts about evidence, California's bill covers a whole host of factors that could potentially be coercive. So withholding food, lying about the seriousness of a crime in order to get a juvenile to confess, lying about, as I said, leniency, and its definition of deception is including but not limited to. So their definition of how they define deceptive false facts about evidence or the accuracy of facts is clear in the bill, but it allows the courts to consider other factors that it considers deception as it so determines. So it's not cabined just to that clear definition of false facts about evidence. And then lastly, the newest state that has passed legislation is Delaware. It beat out California, but California signed the bill first, and Delaware's bill will be signed on the 10th of this month. I just got a text message this morning. It's built similar to Illinois and Oregon, cabins it to false facts about evidence and leniency, and provides a rebuttable presumption that the statement is still reliable. If the state can prove that by preponderance of the evidence, it allows the confession to enter. And so these are the 5 states that have so far passed legislation. There are, as I mentioned, a number of others that are considering it as we go into the next legislative sessions this spring. From our perspective, I think the most key provisions of the bills are false facts about evidence and false promises of leniency, and providing a pathway to prove that the statement is still reliable. So that would get at that issue of, okay, when you are lying about a suspect's identity to protect their safety, or if you're lying about something that's inconsequential to the underlying case, as I mentioned, the example that we talked about in Utah of whether or not your favorite baseball team is actually the Cubs, just a way to build rapport. Though I can't imagine there's a huge contingent of Cubs fans in Utah, but that's what came up. But you never know. That's how largely it's been structured across the states, and it's been what we've put forward. We think it's important to move beyond preponderance of the evidence as a standard to prove that the statement is still reliable, so that it's clear and convincing. My assessment is if you're not, as prosecutor, putting forth a confession that you don't think you could prove is clear and convincingly reliable, that perhaps that confession itself should be circumspect and paid more attention to, and really providing this legislative look at this issue. I think, as the Attorney General's office had mentioned in previous discussions, is the existing framework within the court system is woefully inadequate to pay attention to these issues of false confessions. Every single of the 389 cases of false confessions so far across the country, those underlying confessions were proven to be voluntary and reliable under the existing totality of circumstances framework. And without providing this extra look at these key issues that we found to be inherently dangerous to reliability, there isn't a protection in place. I think Vermont's in an amazingly good spot where law enforcement officers and law enforcement leadership have really moved beyond where majority of the country is and pushing forward into the next level of policing and suspect interviewing, that there perhaps needs to be some more training and more resources provided, as there always needs to be. But I don't think I'm in a place where I am concerned really about how that aspect is working, but we really just need to be able to capture the fringe aspects. If we just solely rely on training itself, then the 1 or 2 officers who do something unintentionally harmful or willfully in some circumstances, there isn't that protection in place for the innocent person who is caught up in that and who was coerced into falsely confessing just because they don't understand the seriousness of the crime, because they're scared, because of a whole host of factors that lead to people falsely confessing. And most importantly, the victim themselves do not find justice. They are not given justice because we seek a closure to a case, but not actually proving guilt, not actually solving the case. We found in reviewing a host of different cases of false confessions and DNA exonerations across the country that over 50% of those close cases involved a perpetrator who wasn't identified, who then went on to commit other serious crimes, whether rape, murder, and a whole host of other things. So as we found, it's an important criminal justice tool to make sure we get it right the first time, because I think it's obvious that if someone gets away with it once, they're emboldened to act in perhaps a more heinous way later. And if we don't, and I think it's more dangerous. So if someone if someone has committed a heinous crime and knows that someone will eventually come after them as law enforcement, they're going to keep their back up and hopefully make a mistake that'll get them caught. But if they know that they got away with it and someone's now incarcerated in their place and the law enforcement is no longer looking for them, how more emboldened are they to act recklessly and dangerously and harm someone else? So we are excited about this new area of policy, as in all the states that have been passed with law enforcement support, and it's really been an issue that has brought various different stakeholders together to push the ball forward. And I'm hoping that Vermont will be next in that. So I hope that gives you a good overview of where things are at as they stand with the states and how this legislation has been considered. And so I'd be happy to answer any questions or dig into this or follow up with the committee with any further information and research that you may need.
Thank you, Nathaniel. I have a lot of questions, but I'm going to open it up to committee members who have more experience in this world. Dick, and then Ginny.
Thank you for the testimony. I have been chair of Senate Judiciary during the time that we did the initial Innocence Protection Act. And at that time, we had stiff opposition from a lot of quarters, including the then Attorney General, William Sorrell. But we were able to get the bill through, I think partly because of the help of the Innocence Project. And the second case was on police use of photo identification and not recording interrogations. Rebecca Brown worked with Vermont on that. It was extremely helpful. So if you get where I'm coming to, if we go in this direction, can we count on help from the Innocence Project?
Absolutely. You can definitely count on our help. I can bring Rebecca down with me. She's a rock star. She's my boss. So
would you say hi to Rebecca for us? And one of the most emotional, I think, testimony we ever had was on the Picking Cotton, the book. And we had Rebecca set up testimony from the victim in that case who identified the wrong person. And then hearing what happened afterwards, that both she and the wrongly incarcerated, actually for about 10 years, went out together and began speaking about the changes that needed to take place in interrogation. I mean, it made it tremendously easier to get bills through that initially had a lot of opposition. So I don't have a lot of questions, just if you're willing to give us the help, I would commit to trying to do our best, at least in terms of the juvenile. And I'm sure the House would also agree that it's an important step forward. I know that, some of the testimony from a man from, I can see him today. He had been a sergeant in the in the Army was at Fort Devens, got accused of rape and spent 20 years in jail. And part of the reason he spent 20 years was he wouldn't admit he committed the crime. Mm-hmm. And eventually they located the evidence, was DNA, in the Middlesex County Courthouse and exonerated him. And that was some of the most powerful testimony I think we ever heard. So I appreciate that, and I'll shut up.
That's great.
Absolutely. We'll certainly be available as much or as little as you may need us. I hope being someone from New England, having family in New England, I might be more welcome as someone who's currently in New York than I am in some states. So as much as you want someone from New York to come and...
Oh, you're welcome. If you and Ben Nowogalski, who's legislative counsel, who would probably be drafting the bill, could work together on that, that would be helpful.
Yeah,
and I definitely consider this as something that, at least on paper, can sometimes ruffle some feathers and put back some.
That assumes I'm on judiciary and not.
I think you will be.
There's been some talk about agriculture in the morning. We'll see who the pro tem is.
To him.
So actually, my question was answered. It was to get access to some of the information that Nathan has brought to us. So it sounds like we're going to get that and it will help to move along. It's great.
Yeah, I will follow up with the committee after this morning and send over the text of all the bills that have been signed thus far in our model legislation, as well as some research and data that we've used with other states.
Thank you.
Butch?
Thank you. Thank you, Nate. The states you mentioned in your testimony, was their legislation juvenile specific, or did they also include adult offenders, sweep any adult offenders in the legislation as they are working on it?
All states have, all the bills that have been passed into law and now will soon to be, all 5 will be signed, have just covered juveniles. Some of those started off just with the juvenile focus. I mean, I don't understand that. Yeah, that's
Sorry. I don't know. My phone does that all by itself. I'm sorry. I apologize.
You sound like my family whenever I'm telling them about work. Yes, all states have passed have just focused on juveniles. A number of those states initially put in legislation to cover adults, but it was trying to get consensus amongst various different stakeholders, as well as from our standpoint is we really see this as an issue that law enforcement and folks from our end of the criminal justice side can come together on. And so we wanted to put, at least for the first few bills, something that everyone would get together on. And I think that that's why we've seen such broad bipartisan support, but also broad law enforcement support for these bills. There are states that are considering legislation and have moved pretty far. Connecticut is one that had legislation that passed first chamber last session in their short session. That bill covered adults, and it covered a broad range of potentially coercive factors, such as California's law has. And there's some other states that I know that will be putting in legislation next year that will expand to adults. I know Washington State is one that will be reintroducing legislation in their longer session covering adults as well. There will be a few others, but so far, only states have only been willing to do juveniles because no one's beat them to the punch, and everyone's kind of scared of being first.
Thank you.
Cheryl?
Thank you. Thank you, Nate. You mentioned that other states are putting legislation in, and you just mentioned Connecticut and Washington. How many other states have legislation that are being?
Yeah, I don't want to speak too early just because the bills haven't been filed yet, but I think I can safely say at least 5 additional states that I've spoken to will be putting in legislation next year. So some states that I can speak out last year, Connecticut introduced legislation, Nebraska introduced legislation, Washington State, Florida's bill passed one chamber unanimously, one committee unanimously. It needs to move, but it ran out of time. And I'm forgetting, Idaho also put in legislation, and there's a couple other states that I believe had looked at it, but it didn't ultimately file bills. So some of those from that cohort from last year will be refiled this year. And then there are a couple other states that weren't in session last year that are, I know a pre-filed, well, I can say Nevada will be putting in legislation. They just, I just talked to the sponsor out there who has put in a request for a bill file. So I think there'd be maybe 3 or 4 to that list that I've spoken with or my colleagues have spoken to who will also be considering legislation this year. Some just focus on juveniles, but a number are focusing on at least up to age 25, if not all adults, as well as juveniles.
Okay. Thank you.
Phil?
Thank you, Nathaniel. I'm wondering, you mentioned that a number of the states had unanimous support from law enforcement and prosecutors. And I'm wondering, it seems from your presentation that age covered in the bill is maybe the most contentious. What would you say is the second most place where you begin to lose that unanimous law enforcement support? What would be the more ambitious piece that they have a problem with?
So it would definitely be the burden for proving that the statement is still admissible. Whether or not it's a preponderance of evidence, whether or not there's a ability to prove something still reliable at all, has been contentious. Sometimes not hard, not. I would say of the legislation I've worked on, and I've worked with the Innocence Project, and I've worked internationally on some human rights issues, and so this is far from the most contentious issue I've worked on in my career. But I think that question of like, how do we define and how do we structure how the court will examine whether or not the statement is still reliable, if it's been proven that these acts have been conducted. I think I think the bigger issue, which is less contentious and more just takes time discussing, is how you define these issues. And so it's not necessarily always clear on paper what a false fact is or what's cabined within that. Having those conversations out has really won the day. I think because we took the time to talk with law enforcement in Utah and really just talk through the bill, we agreed to adding that extra line of reasonably likely to elicit a false confession to make sure that the court would not be capturing these other white lies that go to protecting someone's identity or something else that may not actually undermine the statement itself, but might be necessary in the course of policing, as I think some stakeholders have mentioned in testimony. So just talking that through and seeing through what type of verbiage in those lines are workable and just having that conversation. The language usually hasn't moved too far beyond the bills as they were introduced. It was just a matter of kind of talking it out and everyone getting on the same page of what we mean by the words we put in text, which, I'm saying nothing new to a room full of extinguished legislators.
Thank you.
So I have a question in looking at our statutes that pertain to juveniles and youthful offenders, because I can see that this is going to kind of go into two different arenas here when we're dealing with our juveniles in two different courts, because we've established a youthful offender status for certain crimes that are criminal but not our listed crimes or the Big 12, and they go through family court versus your Big 12 or listed crimes will go through criminal court. And we've been increasing the age gradually in terms of juveniles that would qualify for youthful offender status. How would this interrogation piece play into that here in Vermont? Have the other states have something similar to our youthful offender status or not?
I don't believe any of the states have that similar scheme. That was part of the consideration when we were put in legislation last year in Washington state, was to increase the 25 because they also have that consideration of that higher number of years that we still consider someone a juvenile and having juvenile court jurisdiction. I don't know of other states that have a similar interplay. I could be wrong. I know it hasn't been an issue in any of the other states thus far, but I'm not sure. I can come back to you with answers on whether or not any of the 5 states so far have a similar separation with those courts.
I'm just curious. I mean, I'm a novice at this for the nuance of some of these layers, but that's what came across to me directly. The other piece that I'm curious about, is there a different training aspect for interrogation for juveniles versus adults? Is there a different training requirement, or is it the same for our law enforcement or the entities that are doing the interrogations?
There's certainly different levels of training focused on juvenile interrogations as opposed to interrogations of adults. Each state will differ on that. Within this particular piece, in my experience, for the most part, most states and most law enforcement agencies individually are not using these tactics anymore. They really are of a bygone era that maybe come up once or twice, or either on accident or just in a rare circumstance that it's employed. And that's why the protections are important. But for the most part, it hasn't required a massive shift in training, because this is really where law enforcement has been out. I mean, I think the Attorney General's office in their testimony earlier this year mentioned that the IACP put a report out back, I think it was 2014, and a number of law enforcement agencies have all kind of spoken about this. One of the largest private trainer of law enforcement in the US has not been training on these tactics for almost a decade now, I think. So I know there's some states that have considered whether or not more training will need to be provided to make sure that folks have access to things like the peace method that the state police use in Vermont. But there hasn't been a need really, I don't think, to focus heavily on a training aspect, because it's largely what folks are already doing. And this is just providing that kind of court protection in the courts for those rare circumstances when the tactics are still employed.
Great, thank you. Other questions from the committee? Thoughts? So we will be making some kind of a recommendation, and as Senator Sears mentioned, he's already got a drafting request in.
I think so. And, you know, I don't know.
I don't know on the House
House
side.
wants to do the same, but
Right.
I would probably model it on, to start with, on Illinois and then work backwards.
And then we can discuss as a
Then we can
committee.
discuss how to deal with it, but it would, I think, my fear is if we get into the adults right away, we bog the whole thing down. And my experience is to try to move it somewhat slow. But as Representative Emmons said, a lot of the kids in Vermont who would be dealt with in family court may or may not have this issue. But certainly those higher level crimes committed by young people that can be charged in the adult system certainly could benefit immensely. I think all could, but I just think it'd be more likely where your consequences would be much higher.
Certainly.
Nathaniel, I want to thank you and the Innocence Project for being willing to help us out here. I'm sure that our respective judiciary committees will be in contact with you once we form our new legislative body come January, which is not too far off, a few months away. So any other questions? Thoughts? Thank you, Nathaniel. Really appreciate it. And what a way to come back from vacation. That's the problem.
You're just right back into the fire, which is great. And it's hard to be upset about a morning with a lovely group of folks like you all. So I've had a hostile.
I know. Yeah.
Yeah, I am a lobbyist after all. I got to butter up. But yeah, I'll make sure to follow up in the next day or so with more details on what I provided this morning in writing, as well as the language as recommended.
Right, and Ben will probably be in contact. Ben and Michelle Childs are two legal counsel. Great.
Thank you all.
Thank you. So this is a good segue into our next item. We have the Deputy State Auditor, Tim Ash, former Senator Ash. There was a report that the auditor's office just disseminated on law enforcement training in the audit, and there were some gaps that were highlighted, and the auditor's office reached out and wanted to come in and give us a review of their audit. So I'm going to turn it over to the Deputy State Auditor, Tim Ash. And welcome, Tim.
Good morning, everybody. Nice to see you all in a cyber way. I put together a presentation which I'm hoping will take between 5 and 10 minutes just to capture the major themes which I think are relevant to this joint committee. And I'm not going to delve too deeply into the granular level of the findings, because the larger takeaways are pretty pervasive and are self-explanatory. And then I'm just going to wrap with a few things that I think the legislature in particular should take away from the audit and things that might require action come January, if that works for all of you. So let me get my technology working here.
And for committee members, this document is also on our webpage, committee webpage.
Yes, you'll find both the full audit and this summary on your website. So you can see this slide right now?
Yeah.
Yes.
Okay, great. So I'm just going to begin with the basics. So just as a reminder, when the auditor's office undertakes an audit, we don't merely go out as if we're doing a policy white paper and say, do we like this? Do we think the world should be ordered differently? We go with very specific, measurable objectives to determine whether government programs or spending are appropriate, following the law, following rules, and so on. So these are the three specific questions we were asking. I'll basically summarize. The first was whether people law enforcement officers are meeting their initial certification requirements and whether the Criminal Justice Council had measures in place to ensure that was happening. The second was to make sure the VCJC was ensuring that the annual training requirements were being met by law enforcement officers. There's a 30-hour minimum requirement every year, which also requires specific courses that have to be taken, which are in statute. And then the third was asking whether the Criminal Justice Council had established processes to effectively implement this particular section of statute, which I'm going to pull up in a moment just to refresh your memory. So this is this third objective we were looking at, which effectively said that the Criminal Justice Council's services, ranging from initial use of the police academy to ongoing training, would be prohibited from being used by law enforcement agencies that were not following these three different color shaded requirements. They should look familiar because they've all been added relatively recently by the legislature and signed into law by the governor. The first is around road stop traffic data. The second is around death incidents where death or seriously bodily injuries follow law enforcement engagement with an individual. And then the third is it masks a number of other sub policies, but says that agencies who have not adopted, followed, or enforced the policies that are required in this broader chapter of statute cannot use the Criminal Justice Council. Those policies include fair and impartial policing, having a body camera policy, what's called conducted electrical weapons or tasers, and so on. All right, so why did we do the audit? There are really two major themes. The first is because we all know that these training and policy requirements aren't in place merely for some bureaucratic exercise, but we know that this kind of training and these policies help law enforcement officers deliver a higher level of public service. It helps them do their job better and protects them, and it makes sure that we're protecting the rights of Vermonters. The second is, and this as we look at how we're going to deploy our auditing resources, we're also trying to make sure that we're picking relevant topics. And we know there have been a number of additions in this area of law in recent years by the legislature, and wanted to see the extent to which they were being carried out. Among the recent year additions, which led us to think this would be an important area, fair and impartial policing, we've added both training and policy requirements, meaning that the agency has to have a model policy in place. Same goes for body cameras. They require specific training, and the department has to have an acceptable policy. Same with tasers. Use of force policy changed, so the required training has been modified or required to be modified by the legislature to include new ways of thinking to avoid unnecessary serious bodily harm or possibly death to people who are using chokeholds, for instance, as a more recent debate topic. And then internal affairs policy, which was to make sure that law enforcement agencies had a thorough system of evaluating potential misbehavior within the ranks. And that's something the legislature has required to be included. A few last additional things. The traffic stop data is now almost a decade old, but there have been changes in the requirements when there was slowness by some agencies to provide that data early on. And then these two statutory provisions, which were meant to be, I think, safeguards that the policies and training would occur as expected. The first saying that, as I mentioned earlier, the council couldn't provide services to agencies that have not been in compliance. And then the third bullet here is one that was outside of our scope, but I wanted to call your attention to. This was added, I believe, 2 years ago in statute, which said that the administration, specifically the Secretary of Administration, would not be able to provide grants to any law enforcement agencies that had not been providing these two pieces of reporting, the race data reporting and incidents involving officers with death or serious bodily injury. That one, I just want to park to the side for your further consideration. We don't believe that there's been any effort on anyone's part to make sure that piece is being complied with. Early on in the audit work, I inquired about the amount of grant money that this might include, and the number was about $4 million a year. So it was meant to be a accountability measure, this piece. I don't think that we've seen that carried out the way it was intended. So overall, what did we find? These are aligned with the 3 objectives I mentioned before. First, that the certification of initial officers had a series of shortcomings, which I'll mention a few highlights in a moment. That in terms of the annual in-service training requirements, there was a pretty failed overall system of making sure that officers were taking the required number of hours and the right kinds of classes. And I'll get into a little bit more detail, but in short, the system, by relying on good faith and self-attestation, there was very little effective documentation that this kind of training was occurring in the right way. And then finally, that the VCJC hadn't established policies by which it would prohibit the use of its services if agencies hadn't been carrying out their work of adopting the required policies and reporting traffic data. So all of the recent activities which I had just walked through, it would be safe to summarize that the administrative practices at the VCJC in the years that we were looking at were not sufficient to make sure that they were being carried out as intended. So I'm going to briefly talk about what the audit found within those sort of subcategories, and I'll try to be as quick as possible where it's a bit repetitive. But overall, the issue of model policies, and I mentioned fair and impartial policing, tasers, body cameras, internal affairs policies. While the VCJC knew if they something had been adopted, there was actually no process to determine whether they met the minimum requirements put out in statute that had to basically meet or exceed the standards in the statewide model policies. There was also, this is an area the legislature will want to think about, if there's a change to the policy, the statute does not require that change be reviewed by the Criminal Justice Council. So in the fair and impartial policing policy example, if an agency decided it was going to fundamentally veer from the model policy that it originally adopted, there's currently no process by which that would be reviewed to make sure it was consistent with what the legislature and the executive branch had intended. I will briefly mention one example where deviating from the model policies is somewhat tricky and strange. One agency that was reviewed, and we don't quite know how this happened or why this happened, that removed a sentence from the so-called taser policy, the conducted electrical weapon policy, that said not to use a taser on the abdomen of a pregnant woman. That sentence was actually removed from the policy. I suspect it was an accident, but by taking that out, it highlights the importance of having these policies be reviewed by someone, because an officer following his or her local policy would no longer have that important safety measure included in the policy. So that's why the ongoing review is something the legislature should really think about. And then in terms of the submission of traffic stop data, which has been required, there has not been a policy in place or administrative measures sufficient to ensure that that's actually occurring. What our auditors did was looked at the judicial ticketing system, the information that the judiciary has, to see if tickets were being issued by agencies that were not showing up on the VCJC list of traffic stop data, and found two constables in 2 different jurisdictions and 1 small police department that in fact had not been submitting the racial traffic stop data, which in theory should have prohibited them from having certification from the VCJC. So that's the policy front. On the annual training, I'll go quickly through this because they all follow the same theme, which is poor systems in place to ensure that the training was occurring as directed. In short, the departments themselves would submit an affidavit to VCJC, that's the current system, which effectively checks boxes to say that the officers have received the requisite number of hours in the right kind of training and that the policies were in place for that agency. All the documentation was meant to reside at the local law enforcement agency, not with the VCJC. So there was really no one inspecting to make sure that there actually was documentation to support the training requirements being met. When our auditors reviewed that granular level at the local agency level, you'll see in the fourth bullet, about just over a third of officers actually did not have documentation showing that they met the minimum annual requirement or that they met the specific coursework. And while sometimes these numbers can just sound like numbers, to put it in context, if an officer could not demonstrate that he or she took, for instance, the fair and impartial policing course, and then was involved in an incident where there were issues that presented in a particular engagement with a member of the public that raised questions central to fair and impartial policing policies. The fact that person couldn't prove they had the training raises just a number of issues. So having 1 out of 3 not be able to prove it suggests a pretty serious need for improved administrative steps. The last few items that we found on the annual training, we had some officers, their documentation for the very same course would list a different number of hours. So if 2 officers both need to meet 30 hours of minimum training, one counts a class for 2 hours and one counts it as 30 minutes. It raises issues about the integrity of the grand total number that's being reported. We found some instances where classes were being taken in less than 5 minutes, but counting towards a half hour or an hour or more of training, including one instance where an officer had appeared to suggest that he or she took 3 courses in about a 5-minute period, including the fair and impartial policing class. These would have been online modules. So again, raises the importance of having documentation to truly show that these courses are being taken as intended. Use of force classes are required to be taught by approved instructors. We found instances where they were not approved instructors. Where this could come back to be a real problem is if the courses did not reflect recent legislative changes around the types of use of force which are prohibited to be instructed at the police academy or at any of the off-site locations. And also the conducted electrical weapons, AKA tasers, the current statutory requirement and rules at VCJC are that those are that officers who carry CEWs are required to be trained in their use. However, there's no clarity about who actually carries them, which agencies have them. So that's work for the VCJC to do to bring more integrity to that. And then lastly, on the initial training, just 2 quick ones. The first was a fairly, it's not minor, but reflected one batch of police academy trainees who, if they hadn't passed a class the first time around, there was no evidence that they actually retook it and passed it. We were told by the VCJC that they had in fact retaken the classes and passed it, but there was no evidence that occurred. And then this second bullet is a matter for the legislature to consider. Originally, when fair and impartial policing training became a requirement, there was a requirement that 4 hours be taken. However, it at this time, I'm sure made sense. I might have even been in the room when we passed it, but said that had to be done through, I believe, 2018, but was silent about the manner in which fair and impartial policing training requirements would proceed. The VCJC has maintained its belief that it should still be 4 hours, but in 5 of the 10 officers that we looked at on this question, 5 of the 10 had received less than 4 hours of fair and impartial policing training. So that's something the legislature should consider clarifying one way or the other. So wrapping up here, the legislative considerations, these are the first 2 come from recommendations in the audit to the legislature. And the first relates to the last point I was making, which is considering whether to clarify the specific number of minimum hours of fair and impartial policing training. Right now, statute could be considered either vague or silent on this question. And if people are comfortable with it being as little as a half hour or an hour, that's for the legislature to decide. Its original hope was that it would be much more substantial than that. The second relates to whether or not the model policies agencies are required to have, if there should be an ongoing review requirement so that any changes to those policies would be reviewed and either approved or not by the VCJC, which currently I mentioned is not happening. The general oversight of VCJC progress on all of the audit recommendations, I think, is pretty self-evident. I should add the period of the audit actually preceded Heather Simons, who came aboard as the director of the VCJC. Director Simons has been very, very collaborative with our auditors. I don't think anyone enjoys receiving a phone call from our office. Nonetheless, Heather was quick to have staff provide as much help as possible. And then lastly, this was outside the scope of our audit, but because many people on this committee have had a hand in the A-RIDE requirements that I believe were put in place in the period somewhere between 2017 and 2021. The language in the law actually said that all officers, not just some, but all officers are to have 16 hours of A-RIDE training at the end of the last calendar year. VCJC has been telling departments that requirement did not apply to all officers, only level 3 officers. But we know that it has not been occurring consistent with the letter of the statute. The VCJC had talked at their council meetings about seeking an amendment to the statute, but at this point have not done so. So the legislature has to decide whether it wishes to impose that requirement on all officers or make a modification to only apply to some people. So that's one we wanted to flag, even though it was outside our scope. And then I just wanted to conclude with an example that we put together to, I think, illustrate why the kind of findings in our audit aren't really just a paperwork snafu, but represent a real world example where the many requirements that the legislature and the executive branch have imposed could come into play. And I won't read through the example, but I think when you think of an officer being called to a very stressful 911 call, or as part of a patrol, arriving at a scene where there could be domestic violence, where there could be mental health issues going on, where there may be factors that implicate fair and impartial policing, where physical violence is threatened to either someone else at the incident or the officer, him or herself, where the use of force is a consideration. All of those policies have been put in place for a reason, which is to protect the officer in that situation, to promote public safety and protect the individual at the other end of the experience. And when we can't be sure those are occurring, it undercuts all of those elements that the policies have been put in place for. So let me figure out how to stop sharing. How do I do that? Oh, here we go. Hold on. Have I stopped sharing?
Yes, you have.
All right.
You're back on the screen.
Great. For better or worse, I'm back on the screen. So that was the audit, and I want to conclude by saying that the work was not to flag and shine a light and punish individual officers or agencies, but was of the Vermont Criminal Justice Council's administrative actions to carry out these functions. They've accepted all the findings and have indicated their interest in moving forward. But as I pointed out, some of these are questions really for the legislature, working with the BCJC and others for you to consider.
So Tim, I want to thank you and the auditor for doing this. I'm sitting here feeling very troubled that this has been occurring. I am very concerned about the results of this report. And I'm concerned from a variety of arenas. Our law enforcement entities, agencies have been under a microscope for the past 4 or 5 years. And it has only escalated. And it's escalated almost to a point where our local law enforcement entities are so understaffed and really finding it difficult to find recruits. And then you layer this report on top of that dynamic. We're really highlighting that our officers are being put in a real untenable situation legally. Our towns are being put in this position. And I'm not going to be pointing fingers at either the council or local law enforcement. But it really shows that we have a volatile situation occurring here in this state. And I think we as legislators really need to take care of this next session, because if we want our public, our taxpayers and our Vermonters to be protected, and we want our local law enforcement agencies to be protected, we need proper accountability in training across the board. And I'm really concerned that that's not happening, and it's putting everyone at stake.
Representative Emmons, I'll say a couple quick things in response. I think you've quite eloquently stated your kind of summary of the landscape. One of the things we found is that many of the law enforcement agencies themselves were unsure quite how to comply because the guidance hadn't been very effective. And that is one of the things the BCJC, in accepting our findings, has taken to heart, that to tell an agency that they have to maintain documentation, but not what that documentation has to include, how it's going to be handled so that it's easily accessible, things like that, obviously put the agency in a difficult position because they've got so many other competing demands on their time. So we were very heartened that the council intends to support the local law enforcement agencies by cleaning up any of these activities. And you all will know better than me, but I believe the budget included this year some additional support for staffing levels at the BCJC to help take on some of these assignments.
Thank you. We do have some questions here, Phil, and then Jenny.
Thanks, Tim. I almost can't imagine a worse audit of a particular council or agency and a specific set of legislative tasks they've been given, or oversight tasks. And I take the chair's point about not pointing fingers, but when you have a broad systemic failure like this, there is responsibility to be taken somehow. I understand there's a new director, and I think it's promising that she's accepted the recommendations. I guess what I'm wondering is, I'll call it the across the board failure to certify or verify training requirements, documentation, the whole range. Was that because the council didn't somehow see that as their job, or were they just overly optimistic in terms of allowing self-certification, or was it a failure that they thought they were doing something that they were just failing at? So in other words, there are three major scenarios I could see for how you would wind up with this result, none of them good. but your thoughts on how it got so bad?
Well, so a couple quick reactions. The first, I want to be clear, to be fair to all involved in the work that's captured in the audit, that the audit doesn't say that people weren't receiving required training across the board, merely that the documentation was very ineffective at confirming that people had received the required training. And then the oversight of that documentation was not effective to even confirm in some instances that people had met the bare minimum requirements. The agencies, the chiefs of the local law enforcement agencies or sheriffs, whoever the lead is in the particular law enforcement agency, on an annual basis submits what's called an affidavit to the VCJC that is intended to confirm on a self-attestation basis that all the requirements have been met. The VCJC has accepted that, I think, on good faith, that represents accurate information about both the training and policy side. Our audit found that relying on that was not a successful strategy because, in fact, the compliance was not consistent with the expectations of the council. So rather than opine about what the thinking was of the VCJC, that's really not for us to say. We would merely say that by relying on very weak and very high level self-attestations, the council couldn't really be confident that the contents of that affidavit, what's supposed to be behind that affidavit, was truly accurate. And that's why we were very, and I'm glad you acknowledged that the council intends to take these steps to tighten things up. We found that was encouraging because that's exactly the goal, is to not leave these things in this gray zone where people can't be confident that things are being followed appropriately.
And just a couple of comments to follow up. I'm thinking of what we do in terms of recertifying and relicensing teachers. Long, laborious process, lots of documentation required, and lots of complaints about it. But the complaints are not that we haven't properly regulated the process. Complaints are usually the other way. And that's because kids and vulnerable young adults are at issue. And here it's even worse. You've got use of force, deadly force, et cetera. I'm thinking of, the various back and forth the chambers went through with the use of force policy. We finally settled on something, and, to feel as though there's, if not the policies being ignored at that VCJC level, allowing self-attestation to kind of permit a fog of untruth to get out there, I think is really a bad road. So I take your last point was that the legislature should be conducting oversight of the VCJC's progress on the audit points. Any thoughts on how we might best do that?
It could be as straightforward as having this committee have an update, after the next legislative year, ends, or it could be through the standing committees that are relevant to the topic. It's been, I think many of you know that some of these issues cross across a few committees, including government operations, judiciary, corrections and institutions on the House side. So that would be one possible way. The other piece you mentioned, educators and their licensure process. There is a passage in the audit that tries to compare the manner in which law enforcement officers indicate that they have met the requirements for certification or recertification, and compare that to a number of other professions that are often overseen by OPR. And the basic difference is that at OPR, it is almost always on the individual licensed professional to submit documentation to an OPR system, whereas in this instance, it is up to a local law enforcement chief to kind of check a box and provide very shallow level information to the council. So we suggested that that might be a direction they want to go in. And while doing the audit, discovered that and I'm going to space on the name, but the council that oversees fire training is actually moving in exactly that direction right now. Have adopted a system where individual fire personnel will populate some kind of online system to just have a much more clean and effective system of certification.
Jenny, Teresa, and Dick.
So, thank you. You've actually gotten right into where I was going to begin, I think. But as you're talking about certification, there are professions where software is available that the printout absolutely, or the electronic record identifies that the person has completed the work, and you can't do it in 5 minutes. So having an assessment of how this all happens is so critical. This is too important to ignore. And it does, in many ways, it can't be left up to the individual law enforcement folk, municipalities or the sheriffs. It has to be more ubiquitous and go through some centralized location. So I suppose VCJC is the place. And that also raised the question about the rulemaking authority and whether rules were promulgated for any of the issues that we're talking about. I know that VCJC does issue rules. Well, it would seem to me there's an opportunity here for review, not just of guidance, but also of rules which sort of implement the legislation. So this is rife with opportunity, but it's also extremely upsetting. So I appreciate the work that you've done. Thank you.
And Senator Lyons, I believe the additional resources in the budget were to support the addition of an attorney at the council. So this issue of whether the promulgation of any additional rules or modification of the existing ones is good timing for anyone who's interested in following up with the council.
Teresa, Dick, and Butch.
Thank you. I just want to make sure that I'm understanding one aspect of what you were saying in terms of any kind of acceptance by the council of what was being submitted to them for documentation. And did the council not do any kind of, I guess what I would call quality control? Did they not do any kind of, like, even on a sample basis to verify what was submitted to them was actually accurate?
There's no one answer to that because they handled some elements differently. So the issue of model policies, and there have been a series of strategies in recent years, but where agencies were required to adopt a model policy, for instance, or its equivalent. And as we've determined, the council was making sure that a policy was adopted, but we're not reviewing it to ensure where it was different, that it didn't have a system to determine whether changes were acceptable, or if it was a policy which was on the same topic but was not the model policy, whether it was acceptable. In the instance of affidavits which included training representations, we found incidents where the number of hours, say, might have been less than 30, but there was no follow-up. And 30, just as a reminder, is the minimum allowable amount for certification. Another example, there were some agencies that do use tasers, and some officers did not have it really is a box that says CEW, and you check the box to indicate that they've received that training. So some officers just didn't have it. Now could be because that officer does not carry a taser, in which case there's no problem. But there was no follow-up in instances like that to make sure that the law was being complied with, that the rules were being complied with. So it was a bit spotty, I'd say, in terms of that. And the audit work we do, just like whenever you have a financial auditor come in, they say this is not representing 100% of all of the, every single officer's training. We looked at 60 officers in 12 agencies and the policies at 12 and found evidence of these kinds of occurrences. So the extent to which they extrapolate out to the rest of the roughly 1,300 officers, we can't say with certainty.
Not with certainty, but with some supposition.
Right.
It's troubling for sure. So thank you for this work.
Dick and then Butch.
Thank you, Tim. Good to see you. I'm glad your bookshelf is still full. Doesn't look like much has moved.
It's starting to sag because
I do appreciate getting my book back, so there is one less book on the shelf. I want to echo Senator Bruce's comments about the use of force. Having spent so many hours in conference with the House and the administration on that issue, to see it to think that non-qualified people would be teaching use of force at the Criminal Justice Training Council, it just boggles my mind. That was one of the most serious issues that we dealt with. And I just can't count the number of hours, and I know the House members would share that concern. It just bothers me. Regarding the ARIDE, I don't think there was any question. That was as my recollection is, that was part of the cannabis bill. I believe the initiative came from the House Transportation Committee, who were really concerned about a cannabis bill without some form of enforcement of drug driving laws. And so that's where that generated from. I don't know how there's a question about whether all law enforcement should be involved or not. But I would rely on my House colleagues on that if I'm mistaken. But I think that was part of that overall cannabis bill. And as you remember, there were a number of members of the House who were really, I'm not suggesting the Senate wasn't concerned about drug driving, but who were really, that was a major issue and stumbling block. And the third point, I do think it's necessary for a future audit to look at the compliance now that we have a new director and that things are in a little different shape over there. But I don't know how there could be any need for legislation on the ARIDE, but if there is, I'm happy to join. But I'd like to hear from either Maxine or Martin or anybody who remembers the House position on that. On the ARIDE.
Maxine, do you want to weigh in?
Yeah, Senator, I think you are correct. There was concern, and so you're correct.
And for folks who are watching out in the public, can someone explain what ARIDE stands for?
Advanced Roadside Impaired Driving Enforcement. It wasn't just ARIDE.
ARIDE, then go for a ride. Right. Butch.
Thank you. So, Tim, and for the committee, in a sense of transparency, I did visit with Director Simons on Monday at her request. Obviously, after seeing our agenda, and you expressed your opinion that her concerns are sincere. I think I heard that from you. And I think I have the same, after talking with her, I think I have the same observation that she, for lack of better words, wants to do better. But I do have a couple questions for you. You listed, I think, 8 recent year additions that were, can you tell me what recent year additions means? Did it just come out of the last legislative session, or is it several sessions past?
I was, Representative Shaw, I was trying to sort of summon to mind a number of additions to statute most of which occurred really since 2017 or 18. But also it does include the traffic stop data, which is a provision which I think dates back to the earlier part of the last decade. So those were meant largely to be illustrative of the importance of this and the front of mind policy prioritization. But most of what was in there were relatively new requirements, either in terms of model policies or required training. And so,
So I have some hope for, we've reconfigured the Criminal Justice Council with a whole lot of new members. And I think they're still trying to, a little bit, they may be trying to gel or understand what their charge is. But I think it probably, we might see that with a little more clarity as the year goes by, well, how they're working together. And it's interesting to hear you say that do we have too many House committees or legislative committees? And now let me frame that.
Be careful. Be careful who you're asking.
Do we have too many people?
Can we take a vote on that?
Yeah. Let me try this again. So Tim, you listed 3 committees that could have jurisdiction over these issues. Is that is that a problem? Do we, in your opinion, do we not have one place to go to follow up on these type of things outside of this committee?
well, I'll respond to this first. I don't really have an opinion about whether it's a function of too many committees and therefore no one committee stepping up and taking ownership of it. I think probably in this instance, it is a function of a number of legislative priorities being adopted over the course of a handful of years. And then the legislature turning its focus to other things, including a global pandemic, and you're missing the step of going back and making sure that things have been done as intended, especially with issues that are so important involving, the powers that we grant law enforcement officers. How the legislature handles, I will briefly go off deputy auditor script and say that how the legislature holds programs accountable has always been more of an ad hoc approach. On the one hand, we have a government accountability committee, but it hasn't really focused on that kind of oversight and accountability on program performance. It's focused on other elements that are important but different. And then individual committees, when they discover sometimes that things aren't going quite as according to plan, take the reins. So in this case, we hope our audit has stimulated those who are interested in these issues on whichever of those committees they happen to sit, to step up. Butch, Representative Shaw, to your earlier point about the new council, I just have two quick thoughts about that. One is that many of the administrative shortcomings that were discovered in our audit really precede the newly constituted council. So while it is certainly true that there are new faces on the council itself, the administrative problems stretch both before that and have continued. Again, that's not about finger pointing, but saying that those are really staff level administrative activities that just need to improve. So that's that. And the second is with the council itself. We've seen their minutes and know how hard it is for many of them who meet perhaps at a monthly committee meeting and then a monthly full council meeting. And then they've been given oversight of a large array of duties, including the Vermont Police Academy. So this is just one part of what they do. The council itself can speak to whether it feels not up to the task, but feels like it can handle all of those in their somewhat bifurcated nature, where they've got a relatively small staff and then they've got this council that meets almost like a board of directors. That's an interesting governance question that others should opine on.
Thank you. And maybe for the committee, we could discuss that. Who's going to keep track of what's going on? Make a recommendation.
And Representative Shaw, this gets to Representative Wood's earlier point that we did encounter some issues with some local agencies getting access to information, and it was not, from our point of view, because of an unwillingness to get the information. It's because of staffing issues at the local level. Whether it was, a very small department might have one person who is essentially taking care of all the administrative duties. If that person's not there anymore, it causes a real problem. One of the agencies, I believe Town of Hartford was one of the departments, and they've had turnover in leadership roles. So this question of moving forward, how to ensure that all of these priorities are being carried out as intended, is becoming increasingly challenging at the local level for the reasons that are well known to the people in this committee.
Yeah, and I did note that you did call out constables in small departments, and constables is one person, which makes it really difficult. And usually many of them are volunteers.
I did not dwell on constables, Representative Shaw. It was an interesting finding in our audit that it is not always clear to the VCJC who actually, the full list of constables statewide, despite constables needing to be certified if they're going to carry out law enforcement duties, which in many communities, if they don't actively do it, many of them have authority to do it. So I know that the government operations committees have I'm just going to stop there.
We won't step into that one.
I'll direct you to the audit itself.
Thank you.
Get there.
Thank you.
Yeah, thank you. One of the first things I wrote down when the deputy auditor started speaking was who's in charge. And it sounds like that's kind of that's the big issue here. But I'm unfamiliar with the statute that created VCJC. So I don't know the answer. Maybe Ben can help me with that. But does the VCJC have very specific, okay, and then we've added on over time, and perhaps with or without staff and without, not getting there yet, but just trying to sort out how the statute related to VCJC might be reviewed to strengthen the work. So I think of the professional boards that we currently have. We have Green Mountain Care Board, we have the PUC, we have Natural Resources Board. They all have very significant work to do that is equal to, and perhaps less than, what this board is doing. So I'm wondering if any thought to that kind of evaluation has been given, and I'm looking at the auditor first.
The first answer in simple terms is that the VCJC is in charge. That's the answer to the who's in charge. I think the first
starting the hen house.
The next step, to determine whether any structural or governance kind of changes are warranted, I think would be to look at the response from the council to the audit findings and recommendations, which are in the back end of the audit, where it effectively says what they intend to do in response to our findings on each discrete item. And if that gives you and others confidence that that alone might solve this sort of legacy of administrative shortcomings, then perhaps you leave it there and just keep legislative eyes on it. This issue of making the certification process more like other licensed professionals is one that the director of VCJC should weigh in on that, whether that's in their eyes a realistic approach. But going through those recommendations and the responses, I think with the director would probably give you a sense one way or the other about your confidence moving forward.
And I appreciate what Jenny said, because I think also, and I'm going to blame Butch on this one, I think, didn't we increase the membership of it too? Didn't we add some
Oh,
folks to it?
it went from
Big.
this to this.
Yeah, and we did that over the last 5 or 6 years, 'cause
Mainly in response to the issues of certification, the use of force, other things. And my concern is, I don't want to repeat about having too many committees, but I do think that particularly in the Senate side, the Government Operations Committee has been mainly focused on this. They're not members generally of the Justice Oversight Committee, but yet they do more of the work that's oversight of the justice system, decertification of law enforcement, et cetera. So it may be that if we were to make recommendations, it might be to add somebody from government operations. I don't know, I think it's the same in the House, but I'm not sure. To this members, even if it ends up adding one more member to the committee, or two more members to the committee, because they have more and more taken over that role with law enforcement. And they probably could answer many of the questions, particularly that are seen in the audit.
And on the House side, I know some of the increase of the membership and the direction for the council was driven by Corrections and Institutions Committee back 3-4 years ago, because we wanted them to become more cohesive in terms of the use of the academy. So that's another layer that plays into this. But on the House side, in terms of the council, it's almost like House members aren't even aware that the council exists. They're aware of it if they're in Appropriations Committee. They might be aware of it if they're in House GovOps. But I think for general knowledge of the 150 members in the House, I would say maybe 5 people really know what the council does. I don't know if I'm off base on that.
No, you're not, as far as I'm concerned, in my personal knowledge.
Nobody pays
This is
attention.
more knowledge for me today than I had previously, for sure.
And the only way that institutions, Corrections and Institutions knows about it is because it oversees the academy. And when we are asked to upgrade the academy, we look to the council for direction. And there were turf battles there between law enforcement and fire departments. Then when you're looking at corrections, we on Corrections and Institutions look to the council, and they're working on this now, which is a heavy lift, is to really come in with recommendation about our correctional officers in terms of training of our correctional officers and whether or not we should have a certification and decertification process for correctional officers. So that's one arena. Then GovOps looks at law enforcement on the House side, but do they really look at the council? And then Judiciary Committee looks at upgrading statute in terms of criminal justice law that impacts the council. So that's where we are in the House. And I see the chair of the House Judiciary, Representative Grad, with her hand up. So Maxine.
Thank you. Yes, House Government Operations is familiar with the council, and they do have jurisdiction over the council. So.
But we never hear about it on the House side. I don't know if that's true on the Senate side.
Well, we do to some extent. I mean, but I think that's how certain things get lost in the, if the Justice Oversight Committee is going to oversee all areas of the justice system, then it should be those areas that are covered by the Government Operations Committee as well. That's just my opinion, but I will, I just,
This is
I'm
trouble.
still stunned by the use of force. I mean, I can understand why there might be confusion about A-Ride or whatever, but I just don't understand how you can have any discussion and not have the use of force be, that was so.
Senator, if I might just to be clear on the use of force issue, we found instances where non-authorized instructors were teaching it. So that certainly is a problem. The broader question.
The guy from Woodside was training people in restraints, then that's a real problem statewide, right? I mean, that's what I saw. The reason we don't have a Woodside in part is because they didn't know how to restrain people properly. And and that's use of force. So I know that's pretty blunt to say in an open meeting, but I'm at a time in my life where I can be a little joker.
Does that come with age? Or experience?
Wisdom and knowing you're on the other side of.
When you can, right?
So, this conversation, I want to, again, thank the auditor's office. And this conversation we're currently having is really dovetailing into our next agenda item, which is really committee discussions on how do we go forward here. And I really wanted an open discussion time with the committee in terms of where do we go for agenda items for our next few meetings, but also we need to start thinking about what recommendations are we going to make. And usually those recommendations sometimes take the form of a report. So if we decide to do something like this, it's going to involve our legislative council that they need a heads up to start working on this. What we've also been doing instead of that over the past few years is recommending legislation, and then members of this committee on the House and Senate side will propose legislation and introduce the legislation on behalf of the committee. So this issue right here really dovetails into a conversation I'd like to have before we take a lunch break, if possible. So is there anything else on this report for the auditor's office? I want to thank you, Tim, and I also want to, again, thank the auditor for doing this. I don't know if you have any last statements.
Just that, Doug was very motivated to do this for the reasons we've been discussing, to make sure we have a good system in place. And Linda Lambert and her team, she's one of our lead auditors, really dove into this. And so I think overall, as I say, people were very collaborative, ranging from the council to the local level, to help us get our work done. And there's a lot of opportunity for improvement. So I just want to thank you guys for taking the time. I'm going to sign off, but all three of the things I put in the legislative considerations that are sort of more specific, those are all in the audit itself as well. So you can direct Leg Council there if they want to better understand the sort of context, broader context of that. And we can, of course, field any questions you have after the fact.
Okay, great. Thank you, Tim. I really appreciate it.
See you, everybody.
See you.
Okay.
So while everything's fresh in our mind, let's have an open conversation here.
Well, I think we should, both of them and our committee chairs have stepped down, both the House and the Senate. So
Really?
can't really report to them, but I think we should probably do a report that to the leadership of the House and the Senate, that we have concurred with the auditor's report, and that we urge the legislative bodies to look at the Criminal Justice Training Council in the light of the audit, and really in a couple of areas and that have been highlighted by which that probably, if we want to introduce legislation, we can, but I'm not, we could do that, but at least look at the legislation. The report should say we look at the legislation that has been recommended by the auditor.
And there's plenty of time in the beginning of the session for legislation to be developed by committees of jurisdiction. Could have a committee bill or something.
So are we headed down the road? I'm doing this so Ben can at least get a heads up. Are we headed down the road of physically doing a report with the recommendations?
I think at least on this area we should do.
Yeah, I was going to go back. I was going back up to the interrogation techniques and thinking that that's a bill. That's something that maybe can be put together.
Yeah.
So interrogations, we would do a bill, make a recommendation, we do a bill.
Seems to be consensus about that.
Yeah.
Is there consensus also about focusing on not adults, on youth.
Yes,
Juveniles, yeah.
juveniles. The other piece, oops, okay, Phil?
I'm just remembering, and Dick can check my memory. I think we had an appeal from Bill Sorrell for greater funding for the VCJC, which we responded to with increased funding. And I imagine there'll be some follow-up in the Appropriations Committee about that. And maybe that's an opportunity to have them report to us about their progress on these, whether they come in for the budget adjustment or whether they come in for the regular budget. They could make the ECJC director could make a interim statement of progress. Because the appeal, as I remember it, was that they were going to need additional funds to be able to fill out their portfolio, and this report is pretty damning in terms of what we're getting. So
What we're getting for,
the question is,
Are we getting it for what we added?
yeah, who gets the funding? Because the training council may not need, because they were given some money for a attorney to staff them.
Yep.
And does the academy, who does the record keeping and the training and all that, do we direct money to them to carry out the mission that the legislature's asked them to do?
Yeah, and maybe that would be the outcome of the discussion.
Right.
I guess what I'm saying is the multiple committee jurisdiction doesn't have to only be a weakness in our system. It can be a strength. We can have a couple of different places where we're asking for accountability, and one is over that increased funding, especially if they come back for a further.
in that one too, we should reiterate that if you don't provide the racial data, I don't care whether you're a constable or a state police, you don't get the money. You don't get the money. You don't get the money, you don't get the training council. I think that should be really clear. I don't know how you headline it, but that really.
Well, without a link to the training academy, local police departments can't exist.
Right.
What do you mean a link?
Well, they have to be connected to.
Connected electronically, you mean?
No, they have to be, I don't know what.
They have to use it.
They have to be able to do certain types of training at
the academy.
through the academy.
That was
Yeah, oh, okay. And they
But that
can't
was
get
a-
there because state police
That was
uses
a
a lot of
key
the
element
space, right?
of the fair and impartial policing was to not provide grants and not provide access to the criminal training council for those agencies that would not participate in providing data on fair and impartial policing.
So it's a pretty big hook.
I know, but if it's not,
But part of what you're saying is the availability of space for training at the academy.
I wasn't trying to,
May not be
I don't think I was
available.
trying to say that because I think they've worked through some of that, but it's just that local police departments have to be connected to the academy at some level for the training that we're asking them to do. And if they're self-certifying, then that's not a good connection.
So what we're talking about now is a short report that would go to committees of jurisdiction.
The way we've done it in the past would be we do one report and there would be our recommendations. So one of these recommendations is that the House and Senate Government Operations Committee would be the committee of jurisdiction for oversight of the council. Another recommend could be that when we configure the Justice Oversight Committee, we add a member from those two committees to the Oversight Committee. Those are the two things that come and then maybe the third is what Phil was saying, that upon review of their budgeting within Appropriations Committee, there's another review there. Those would be the bullets for our report.
The interesting part for me is that the Police Academy and the Criminal Justice Council report directly to the administration without oversight. that their budget is controlled by the administration. And they present their budget to us, but the budget is then approved or not by, they don't have a commissioner or a secretary to report to. They report directly to the secretary of the administration. Right,
Council.
right,
Yeah.
right. And I don't know if that's right or wrong.
And that may be if we say,
Yeah, that's the governance question.
that's the governance question for GovOps. So I think we've got the context of some of this in a real rough. I'm going to move us along here a little bit because if we really want to do a report, the other piece of our requirement this year is to really look at the justice councils, justice councils. And I'm looking for that section that pertains to, I think we have to give a report in terms of, well, we can submit any proposed legislation resulting from how we see going forward with our community justice centers and the funding aspect. Now, I don't know if that would be something we'd want to include in a report or if we'll end up proposing legislation. We'll know more about that this afternoon because we have some of the directors coming in. I don't want to burden our legal counsel with too much of an in-depth report because I know they've got other reports they're working on as well. One person doing everything.
Can we come back to this after we've finished our agenda today?
We can if we have time.
Okay.
I'm a little concerned on time-wise, but we can. I mean, I just want to lay this out
Yeah.
for folks because we've only got 2 more meetings, and if we do a tour, we do a visit of a P&P office, that's an additional meeting. And if we do a report, it takes a long time, committee time.
The restorative justice, that really,
That's the other piece. Yep. That's your community justice centers. And then we'll be hearing this afternoon thoughts. We have to make recommendations on the Justice Reinvestment 2
Yeah.
funding.
that shouldn't be too hard.
Right. There's 1.9 million, and that would be for possible FY '23. So I just want to lay this out for folks so you can spend some time thinking here before we take lunch. And hopefully there is
Do you
not,
think we'll ever get a report from the Act 57 that related to competencies?
no.
You're on the committee.
What?
You're on the committee that was discussing that, right?
No,
No,
I'm not.
okay.
I'm just worried that we never get a report, we never, mental health, I mean.
I know, I mean, it's,
I just, oh, gosh.
Well, that's another thing to put into the report, is to,
well, the other thing too, if we want to make a statement, is how do we
Well, I'm prepared to introduce a bill that just says build a
forensic?
forensic unit
It'll be interesting.
somewhere, somehow, and direct the agency of human services to do it.
It will be interesting to see if
And
it's in the
building general
governor's,
services.
it'll be interesting to see if it's in the governor's recommending the capital bill.
Well, I think it's probably the only way to push the issue is to just introduce a bill. Anybody wants to join me, I'm happy to have partners. But I just,
So the other issue,
I got a call from a reporter saying, I checked all the states. Why doesn't Vermont deal with this? So, well, we had a hurricane.
so the other issue, and this kind of fell
Right.
through the cracks on our schedule. I just noticed this. We were going,
Make that a drafting request from Senator Lyon, Caruth, and Sears, and Senator, well, Senator Hooker won't be with us, so.
this fell through the, we're
If you
supposed,
could,
this was,
it's a simple little bill.
this is, fell through the cracks on our agenda because we have another item this afternoon, which is not on our agenda, which we worked on was housing of juveniles. And we
Yeah, no,
were-
it's on the agenda.
It's not on.
Update on placements of violent, 2
Am I
o'clock.
pulling
It's on the
wrong-
top of the back
It's on the
page.
back.
Pulling the wrong agenda. Sorry. Phew. It's time for lunch, but this is another issue too, that we can make a report on, is placements of violent juveniles, because nobody's budging on that one
There isn't
either.
anything, well, but it's
supposed to give
a report.
A report.
Yeah, it's in the court.
Well, I think today I'm hopeful that they'll have something more concrete at 2 o'clock.
You're hopeful.
I am. I've had some discussions with both commissioners, but it's,
So we've got a full afternoon, so let's go take lunch. Hopefully there isn't a tourist bus at the cafeteria, because it is fully. So for folks who are Zooming in, and also for the public, 1 o'clock, we're due back.